Hello, this is the auto review for contract law. In this chapter, we'll be looking at what are the elements of a valid contract. We'll look at the provisions that are commonly seen in sport contracts and other employment contracts. We'll look at the type of contracts that are found within this industry, and we'll look at what happens when a sport contract is breached. Some examples of sport contracts: player, team, agent, player, teams with sponsors or media, spectators with the team, which would be your ticket, employment contracts, collective bargaining agreements, team leases, all sorts of different types of contracts. When we think of sport contracts, we want to make that even bigger and say it's business contracts. So where in these businesses do we have this overlap? Where do we have this in terms of being able to connect to other people and create a contract is what we'd be looking at. Like other elements of law, contract law is very specific with its language. So the formal definition of a contract is a voluntary agreement that imposes duties and benefits upon the parties. It is a promise or set of promises for which, if breached, the law will provide a remedy. It's more than just a promise. It has a remedy to it. A promise is similar, although under a court there is no availability of a remedy. If you promise something to somebody, it's not a contract specifically, then there's no enforcement of it. We have an express contract, and whenever we see the term express in law, we think of oral or writing. This is where the parties clearly state the terms of the agreement, either written or verbally. An applied contract is a contract that no proof the formal exchange of promises are available to us. It's implied, it's not written down, it's not orally agreed to. We consider a contract that is enforceable is valid. A contract that fails to meet the legal requirements of a contract is void, and voidable provides an option to cancel it. Perhaps we have a contract where a employee or a player or coach can void or get out of their contract after a certain amount of times. That would be voidable. Some different types of contract. There's a bilateral contract. A bilateral contract is a similar contract, a common contract that we know of. A contract consisting of two promises, and both parties are bound to perform something conditional. For example, a player plays a game for money. You sign an employment contractor. In exchange for your salary or compensation, you will be given your effort or some sort of work or some sort of level of employment. There's a unilateral contract. This is a contract that has an exchange of promise, and there's only one way to really fulfill the contract. It's not meant for a specific person. It's not a one-on-one like a bilateral contract. For instance, a agreement at a auto race where the winner gets $1 million. The only way to fulfill that contract is to win the race. So there's only one method, a unilateral contract, something extended from one person. And there's an option contract. An option contract allows one person to keep the offer open for a limited amount of time without necessarily having to agree to it. We're going to look at the elements of the contract. We're going to look at offer, acceptance, and consideration. Most books talk about 3 elements to a contract: offer, acceptance, and consideration. Some extend it to 5 with legality and capacity. We're going to hold the elements specifically to be offer, acceptance, and consideration. Legality and capacity are conditions that make it a contract. An offer is made by an offeror. What is an offer? An offer is the exact language of what needs to be met with this contract. An offer creates power of acceptance, meaning by making an offer, I inform the other person of how I want them to accept it. You want to sign it at the bottom. To accept this contract, you're going to provide a certain amount of employment. I'm going to provide a certain amount of compensation. Offer this for that. If you do, in a bilateral contract specifically, if you do this element, I will perform this condition. Acceptance, very easy. An acceptance has to accept the initial offer. It must be done in a positive manner through words or conduct. Either I accept or I'm writing it down. The key here with the acceptance is there is no change to the offer. There is no disagreement with the terms, either the amount of money or the length of time or any condition that's put in there. If you do have a difference of opinion, then that is not an acceptance. It becomes a counter offer. Other information about an acceptance. It's only made to the party to whom the offer is made. The acceptance must mirror the original offer as to the offer's essential terms. If the acceptance does not mirror the offer, there's a counter offer. The offeree may accept it by signature, verbally, or performance, or some other mode permitted by the offerer. And there's kind of an antiquated mailbox rule where the offer is accepted when the acceptance is sent. So if it's lost in delivery, it's still considered an agreement because the person agreeing to it or accepting the offer has made it in a certain amount of time. What distinguishes a contract from a promise is consideration. Consideration is the exchange of value. I am providing my work effort, you're providing me compensation. I'm providing, in terms of a waiver, which is a contract, I'm providing, you're providing me the experience, the ability to participate in the sport organization. In exchange for that, the consideration that I'm giving is I'm not going to bring a lawsuit. Your ticket, in exchange for allowing me to watch it within the stadium, I'm providing you compensation. Consideration is an exchange of value. Without that exchange of value, it could be a gift or it could be a promise, neither of which is provided a remedy based on the law. Different types of consideration: money for the promise to provide a meal, money for the promised use of an arena, promise by a restaurant to host a Halloween party, in exchange for decorations. So consideration is an act or a promise not to act. Promise to pay a salary for work of an employee, promise to release a worker from an employment contract if she agrees not to open a business in the same geographic area for a certain time. Forbearance is a promise not to act. So it's either an act or not act. That's the consideration, an exchange of value. Offer, acceptance, consideration. Offer, acceptance, consideration. 3 elements to a valid contract. Moving forward, there are other things that need to make a contract valid. However, most do not consider it an element. Legality and capacity. Legality means a contract is only valid if it covers legal elements, meaning you would not be able to uphold a contract to murder somebody or buying alcohol for somebody under the age of 21. It has to be legal elements, has to be a legal context in order to have a valid contract. And capacity. One reason why waivers are not necessarily enforceable against children is minors cannot enter into a contract. Minors, people under the age of 18, can't enter into a contract. Other people are mentally incompetent, intoxicated, under duress, other types of elements that make capacity an element where it's either valid or not valid. Some provisions that are in typical contracts, the parties. The contract typically describes exactly who the parties are, Mark Dodds and the Miami Dolphins. Whoever the 2 parties are or multiple parties, an agreement, a contract will clearly identify those. The provisions will cover the term. How long is this contract going to be in effect? Any warranties or representations, what legal promises, what conditions, what is each party responsible for doing? And a termination. Is there a way that we can get out of this contract? Is this contract voidable? We can look at AT&T versus NASCAR to show different elements of all these people who may be a part of a contract or may not be a party to a contract. Other specific types of contracts. We're going to look at a college contract. We can look at a student athlete, which does sign a contract with a college, the National Letter of Intent, and other types of specific contracts. However, It is not an employment agreement. Just because you sign a contract that says I will attend this college does not make that an employer and employee agreement or relationship. We'll look at Ross versus Creighton. We'll look at Hendricks versus Clemson. A number of these not only represent the college, but also at what level do advisors have to provide proper advice? What creates a specific contract and what elements don't? What's the difference between a promise and a contract? Athlete employment contracts, they're governed by the collective bargaining agreement. A collective bargaining agreement is a labor agreement between employers and employees, or a league, their owners, and the players union. A part of this agreement is a uniform players contract. It's a standard contract that all players within the major professional leagues sign. You can do some different things in there. Obviously, some terms are left open, like the amount of money and the term and the parties, but standardized. What are you supposed to do? What are your conditions? What is the how will you be paid? When will you be paid? What is your employment contract? What are your expectations for labor? All of those are standard. You can do an endorsement contract. Also, athlete agent representation agreements are all agreements in this type of professional aspect. We'll look at Waldrop versus Texas Employers Association, not necessarily a professional contract. However, this again goes into what a student is and what a student athlete is, and are they employees? Certainly this ties back with that earlier video school that we watched. Employment contracts with coaches. College and professional coaches are very highly compensated. Not just their initial salary, which is very highly publicized, but also other types of fringe benefits, things like speaking engagements or summer camps or Nike or Adidas sponsorship money that can be given directly to a coach, or media, radio shows or television shows. All that may be included in compensation for a college or professional coach when it's not solely salary. Other employment aspects that we'll look at: termination. We see this on both sides, and a contract does have availability of both sides. You want a coach who's able to perhaps, how do they get out of a contract in order to move to a better for them situation, either more money or more lucrative association? How can a college remove a coach? Or if you look at in terms of just any employee, how can employees leave without breaching a contract? Or how can an organization fire somebody or release somebody without breaching the contract? Covenant not to compete is that forbearance. It is an agreement not to do something. So a covenant not to compete means I will refrain from opening a competitive organization within a certain amount of time in a certain geographic area. Maybe easier to see this in terms of a dentist or a doctor that has a partnership. They can leave that partnership. However, it's not necessarily fair to the rest of the partners if they go across the street and open up a competitive organization and take all the clients with them. So what a court will do is allow this covenant not to compete, but looks at it in a couple of different ways. One, it can't be overly burdensome based on the amount of time or the geographic area. You're not going to be able to say you're refrained from opening a business anywhere in the world forever. Maybe 2 years within 50 miles, something that seems reasonable to a court, they'll uphold the covenant not to compete. But they certainly don't want to punish a person, an employee, from opening up their own employment area. We look at that when we discuss the Northeastern University versus Brown case. It really gets in this covenant not to compete. Is Brown allowed to leave one college for another college? What if that new college is a higher level? He's leaving here from Northeastern to go to UMass. What if it was Boston College? What if it was UCLA? What if it's a more lucrative school for a lot more money, a lot more prestige? Will a court allow them to go? Rogers versus Georgia Tech talks a little bit about the benefits that a coach may have in terms of country club memberships or free car or house, Are they able to recover upon termination for all of those different elements or just salary? Vanderbilt versus Donato talks about how a coach wants to enter into an agreement, specifically told to him how he can enter into sign it, doesn't follow those specific steps. Does that contract become valid, or is it voidable, and is the coach allowed to leave and go somewhere else? Monson versus Oregon is a case where there's a coach in Oregon and the college wants to remove him from being a basketball coach. Can they reassign him to another position? Can he become a golf coach? Can you be reassigned within your organization doing a job that you not necessarily are qualified to do or hired to do? Or does that just create this element where we're trying to drive you out and you quit? There are game and event contracts where the contract for the individual game or the contest itself, you want to look at different types of contracts, including when do you take possession of the arena? What time is load in and load out? Do you need to use their employees, maybe union workers? What type of intellectual property do you get? Do you get to use the NFL shield or the team logos? Who owns television rights? Who pays for travel expenses? A lot of game contracts you're looking at now as we're growing bigger between this FBS and the FCS level. If you're one of the Power 5 schools, you're bringing an FCS school in, who's going to pay for travel? How much compensation are they going to get? If you go to a bowl game, who pays the travel? Who has to buy tickets? Where can you get your hotel from? Concession merchandise agreement. If I'm bringing an event to an arena, do I get to keep all the concession, or does that go to somebody else? And who's going to run that? All of these specific terms, all of these conditions have to be written down in order to be upheld in a court of law. If it's not written down, you may not get exactly what you want. Rent, insurance, when do you get to possess the arena? All of these different elements need to be a part of your contract, whether it's the game or whether it's employment. Anything that you think you deserve or anything that you want in terms of company car, vacation time, employment, moving expenses, that has to be written down or else it doesn't exist. City of New York versus New York Jets talk about impossibility. If a contract is impossible to uphold, meaning maybe it's an employment contract between you and an employer and the employer goes out of business, it's impossible for you to keep that employment agreement. Are you now allowed to void the contract and go somewhere else? Like I said earlier, a waiver is a type of contract. It's signed before the event. It's offer, acceptance, consideration. It's enforceable. It's a valid contract. That contract allows people to not sue based on different types of elements, and that is negligence. Assumption risk document handles inherent risk. A waiver absolves an organization from negligence. Another type of contract we're familiar with, leases, where you have an offer, acceptance, and consideration agreement between a facility owner and a team to hold different events at that facility. Common lease that you may have an apartment lease. It's an agreement between the owner of the apartment complex and yourself. Promise to play or stay at this apartment. You're going to accept money for it and consideration. It's a contract. We're going to look at a couple specific contract law issues, parole evidence rule and the statute of frauds. Parole evidence mean if it's not written in the contract, it may not exist. Any oral statements prior to the writing of a contract is not going to be allowed for the most part. For instance, if you have an employment contract and you're discussing with a senior vice president that you're going to come in and start making $75,000 a year, you get your contract and you sign it and it says $50,000 a year. Parole evidence bars you from saying, I agreed to something that was $75,000. The document says $50,000. The document has to be the final expression of intent. If there's not anything that's ambiguous within that area, then we're not going to bring additional information or evidence into our evaluation. So if it's outside of the agreement, you may have discussed it. If it's not a part of the written document, it's not a part of the contract. The statute of frauds is an agreement that requires, or it's a law, antiquated law, pretty old, that says certain contracts have to be written down. Selling of land, leases, they have to be written. They cannot be oral. Any agreement that cannot be performed by either party within 1 year has to be written down. Therefore, you have specific evidence of the agreement. A failure by one party or the other to uphold their obligations in a contract is called a breach. There's some remedies that are available to it. Damages, compensatory damages, consequential damages, liquidated damages. We can look at specific performance, whether it's a unique item or a negative injunction, and there's also a duty to mitigate. Under remedies, we have this idea of compensatory damage. You want to be compensated. If you've agreed to pay somebody to build a deck and they decide not to build your deck, you should be allowed to have the money available to have somebody go and build your deck for you. Let me look at the right slide here. Consequential damages or liquid damages. Those are damages, liquid damages are damages that are specifically agreed to within the contract. We know them as buyout clauses, that if you want to leave or if a coach wants to leave after a certain amount of time and go coach somewhere else, in exchange for a certain amount of money, he's allowed to breach this contract. If I want to remove you, if I signed you to a 5-year employment contract and I don't want you to work with me after the second year, I have to pay you a certain amount of money. Liquidated damages means that it's specifically described within that contract. Specific performance is a remedy that perhaps there's something that money can't take of. Maybe you are into a contract for a signed baseball from the 1927 Yankees, and you have a contract for a certain amount of money, and then you go to collect it, and the person's not giving you that item. You can sue for specific injunction, specific performance. You want that item, that's what you can sue for, so the item is unique. A negative injunction means perhaps you've signed Justin Bieber to play at your school arena, and he gets there and decides that he doesn't want to do it, that he has an offer somewhere else for more money. You can prevent him from working that other place if there's a conflict because originally he signed with you. You can't make him perform because that goes against indentured servitude aspects of the Constitution, nor would it really be a good performance. If you're forcing somebody to give a concert, they're going to go in and do the bare minimum, maybe sing one song really poorly and then move on their way. So negative injunction means that we're keeping you from doing something else. I don't have to, you don't have to do what our contract is. There's the breach there, but I'm not going to force you to perform. Duty to mitigate means within a contract, there's a duty of the non-breaching party to find a suitable replacement. This may seem a little bit unfair or strange, but the court is trying to keep as many of these conflicts out of their courtroom and try to resolve as many issues as they can. So if somebody has to breach, the non-breaching party has a duty to try to mitigate the damage, find somebody else to take care of it, hopefully under the same conditions. Capacity talks about that aspect of a minor being under 18, he can't enter into an agreement. Intoxication makes it a voidable contract, or mentally incompetent makes it a voidable contract. It's not necessarily void unless the person or their family wants to keep the agreement. Remedies, again, suit for specific performance, specific contract terms like a franchise agreement. Liquidated damages are damages pre-described in the contract. And an economic loss is one of the consequential damages. But for this contract, you can get certain amount of damages that would be a consequence of what's happening. Recommendations about contracts, get everything in writing. With that parole evidence rule, it really makes it difficult if it's not written to really understand what could be a part of the contract. Read it thoroughly, because if it's written in there and it's not what you agreed to, don't sign it. Keep copies of all contracts. Change elements and terms if you do not agree with them. Note deadlines for performance. Do something to guarantee performance of third parties. Share contract knowledge. Do as much as you can and be very clear with what's going on. Hopefully you can resolve some ambiguities before you actually sign the contract or immediately after it, so you don't have to reach a point where it's a breach. Contracts: offer, acceptance, consideration.